Hi, I'm Attorney Tran. I'm going to talk to you about an interesting trade secret case filed by Tesla against one of its former employees. This lawsuit was filed in the Northern District of California. Tesla accused one of its former engineers of stealing its supercomputer secrets. The engineer, his name was Yatskov, had been hired by Tesla to help it work on one of its new computer system for self-driving. Now, the interesting part about this lawsuit is that uh, Tesla has made some allegation that this individual had secretly retained trade secrets in the short period of time that he worked there. And when they confronted him about that, he had provided them with a fake dummy computer. So let's go into the facts of this lawsuit because I find it pretty interesting. Number one is that this lawsuit was filed on May 6, 2020 in the Northern District of California. It's assigned to Judge Donato. You can see that not a lot has been filed. You have the complaint filed on May 6, and then you have an assignment to Magistrate Susan Cullen. Magistrate is responsible for handling miscellaneous motions. And one of the motions that they filed on the same day they filed the lawsuit, it's an ex parte motion for temporary restraining order and a motion for leave to file additional documents under seal. This is pretty normal as far as filing documents under seal because when you have trade secrets, you have to tell the court what the trade secret is about. You need to file it under seal, otherwise you would have disclosed the trade secret in public. So under seal is normal, but let's take a little time and take a look at the lawsuit itself. So um, the lawsuit is 13 pages, which is normal length for a trade secret case, but the facts are pretty interesting in that they hired this gentleman as a thermal engineer to address some of the problems in designing a custom computer. And this gentleman apparently had listed his work history and expertise in this area, but Tesla is alleging that he didn't have the skill and that he may have misrepresented himself on his job application. So this is pretty interesting. I'm going to stop right here and talk about it. When you have a employee that works for a company, oftentimes in a job application, there's a little disclosure statement that says that you shall not make any misrepresentation on your application or in the application process. If you do make a misrepresentation, the company can use that as grounds to terminate you, but oftentimes they use that as cause to explain why they should not pay you certain executive compensation because you had misrepresented yourself in the agreement. Now, let's talk a little bit about the actual theft of trade secret. What Tesla is accusing this gentleman of doing is that he had access his work account through his personal devices. That's pretty normal. A lot of people do that, but it's frowned upon. It's not good trade practice. But that in of itself, I don't think is grounds for theft of trade secret. If you log into your work computer from home, you basically have violated maybe the company's IT policy, but it doesn't mean that the individual has stolen anything. It just means that he didn't follow standard IT protocol, because when you access work computers, work accounts on an unencrypted computer, you may expose your company and company data to hackers and malware that may have been installed on your computer. And hackers often target ancillary or employees, ancillary computers that employees may use, install malware on it, some type of hacking software, and use that to create a backdoor to access work information through the portal. Once the employee accesses that portal, they'll just copy all the passwords. So this is why most companies like Tesla do not allow employees to access data through their home computer. But that's pretty much what they say that he did. And so it doesn't sound as bad, in my opinion, to do that, and it doesn't form the basis for a theft of trade secret case. Now, they do offer one more additional piece of evidence or allegation in their lawsuit under paragraph 3. It talks about um, the employee emailing to his work computer some work files that may be considered trade secret. Um, Tesla does not know how he was able to acquire this trade secret stuff on his home computer and send it to his work computer, but that in of itself is not theft of trade secret. That simply means that somehow he was able to work on um, his do work at home on a computer that Tesla was not able to monitor. They cite to a very common instruction and policy. A lot of companies have it. They say that they had repeatedly instructed him not to use personal computer for work. This could be in the form of an acknowledgement when you sign up for a job at Tesla. Maybe it has a splash screen that reminds people every time you log into work. Say, the splash screen may say, "Don't remember not to use your home computer to access this work data or through this portal." But it doesn't necessarily mean that they verbally confronted him and say, "Hey, don't do this," or gave him a coaching session. So this statement in the lawsuit, it could mean anything. So it doesn't necessarily mean that they caught him and they were trying to teach him not to do that or coached him not to do that. I think it could be something that's very innocent, as just a simple disclaimer that all employees are exposed to and see on a regular basis when they sign into their work computer. The mistake that they did that happened here is that this gentleman went in for an interview uh, and he probably was not prepared, or he was prepared but in the wrong way. They brought him in, interviewed him, and they said allegedly he admitted that he had saved some work material on his home device. And so they're using that as a gotcha, saying, well, that means you stole trade secret. Number two is that they told him to bring in his personal computer for imaging. Now, this is the man's personal computer that he bought with his own money somewhere else. But he brought it in anyways, and imaging means they just get they take out or they connect the laptop's hardware to a special computer where they would examine and make a copy of the platter, or if it's solid state, the entire hard drive. And it has all the divisions of how the files are separated, including all of the drivers and BIOS on there. And so they're able to study this. So unlike a backup image, this is a actual image, so it's a mirror copy. So they got it, they read it, and now they're saying it's a dummy laptop, incapable of accessing the relevant information. But then they further say that that very morning that he turned it in, someone logged onto the computer and tried to access the Tesla database. So it looks like he was able to access Tesla's database through the portal, through his laptop that he turned in, but they're saying it's not the same one. And apparently their IT department is able to distinguish, I guess, the identifier on the laptop or the computer. Each one has its own identifier, and it doesn't match the identity of the computer that logged in to Tesla's work portal through this man's account. And so they're saying, well, this is a different computer than the one that we're trying to track and find out. So they're kind of mad at him because he's now has two personal computers that he used to access their data through the employee portal that they could not monitor because since they're personal computers, they could not and did not install monitoring devices or software. So that's what the lawsuit basically describes. The relief that's being sought well, let's talk a little bit about the cause of action. So the lawsuit is talking about theft of trade secret, and The first cause of action is the Defend the Trade Secrets Act. This lawsuit basically says that you can sue for theft of trade secrets. The second cause of action is a California equivalent of a Trade Secret Act, basically saying that you can sue for theft of trade secrets. The relief sought is pretty common. They're asking for the trade secret to be returned, but at this point, there's no actual proof that anyone has stolen any trade secret, or if this employee stole it, if he shared it with anyone else or another company. Then you have a breach of contract. The breach of contract stems from the fact that he signed a non-disclosure agreement that says that he will not disclose confidential information, but Tesla still has to prove that he disclosed it. So far, they just have some allegation that he had procured this trade secret information and it's on his personal laptop. The relief that's sought by this lawsuit is pretty standard. It's an amount that they don't have measurements yet. They don't know how much you're suing for because there's actually no damage to the company. Attorney's fees and cost of suit, basically the cost of filing the lawsuit. In addition, let's talk a little bit about the TRO. So the TRO was filed ex parte, which means that it's presented before a judge without the benefit of the defendant, Mr. Alexander Yatskov. He didn't, and usually it's not a required party to participate in it because it's a preliminary temporary restraining order, so it's a preliminary hearing. And so they're asking the court to give them injunctive relief. So it's a TRO, and then once it's been granted, then there will be a full-blown temporary injunction hearing. And in order to, the standard to grant a TRO and a TI is that there will be irreparable harm, and the injuries to, potential injury to Tesla would outweigh the inconvenience of the TRO order, the restrictions that's imposed on the defendant in this case. Notice they didn't post a bond. They're asking for expedited discovery. No doubt they're asking for records to prove whether or not he had shared this Tesla information with an outside company. Let's scroll down and take a look at the order that they're seeking. They're asking for a preservation order to prevent the destruction of any evidence that Tesla trade secret information had been taken from the company. So that's pretty much it. I hope you find this interesting. If you do find it interesting, comment below if you have any questions, and I'll be glad to answer those questions, or I'll be glad to do another one of these updates later on.